Society. I'm very happy to have you here today. The Federalist Society for Law and Public Policy Studies is a nonpartisan group of conservatives and libertarians interested in the current state of legal order. We were founded on the principles that the state exists to preserve freedom, that the separation of powers is central to the Constitution, and it is emphatically the province and duty of the judiciary to say the law is not what it should be. One quick reminder before we get started, the Federalist Society will be hosting a happy hour at HG Supply this Friday at 6 p.m. We'll be providing appetizers, so I hope you'll be able to make it and bring some friends along with you. Today's event is entitled Searching for Unicorns, the Lack of Intellectual Diversity in Legal Academia, and we're fortunate to have a distinguished panel to discuss this topic. In terms of format, each panelist will have 12 minutes to provide an opening statement, then a period of time to discuss the topic amongst themselves, and whenever they want, they can open up the floor for questions, starting with any questions from our faculty that are here today. Thank you very much for coming. Professor Josh Blackman is an associate professor of law at South Texas College of Law.
Now the Houston College of Law, in fact.
Yes, yes.
Litigation, never mind. Litigation pending.
That specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Josh is the author of the critically acclaimed, Unprecedented, The Constitutional Challenge to Obamacare, and Unraveled, Obamacare, Religious Liberty, and Executive Power. Josh was selected by Forbes magazine for 30 Under 30 in Law and Policy. He has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He's an adjunct scholar at the Cato Institute, president of the Harlan Institute, and the founder of Fantasy SCOTUS, the internet's premier Supreme Court fantasy league, and blogs at joshblackman.com. He leads the cutting edge of legal analytics as director of judicial research at LexPredict. Josh is the author of over 24 law review articles, and his commentary has appeared in the New York Times, Wall Street Journal, Washington Post, USA Today, LA Times, and other national publications. Adjunct Professor John Browning is a shareholder in the Dallas firm of Passman & Jones. He handles civil litigation in state and federal courts in areas ranging from employment and intellectual property to commercial cases and defensive products liability, professional liability, media law, and general negligence matters. He has extensive trial, arbitration, and summary judgment experience and has represented companies in a wide variety of industries throughout Texas. He is the author of the books The Lawyer's Guide to Social Networking, Understanding Social Media's Impact on the Law, The Social Media Litigation Practice Guide, and 2 forthcoming books, including a book on legal ethics and social media for the ABA. He's also a contributing author to 7 other books, 25 published law review articles, and the award-winning writer of numerous articles for regional and national publications. He's also the article of an upcoming law review article tentatively titled Searching for Unicorns, the Lack of Ideological Diversity in Law Schools, which is quite fitting for today's discussion. Finally, last but not least, Professor David Pianto is an assistant professor of law at SMU, where he teaches torts and evidence. His work applies economic reasoning and insights from the field of psychology to the study of torts, remedies, and social norms. His specialties and scholarship include law and economics, law and behavioral economics, torts, law and social norms, evidence, empirical research, and public policy. Please join me in giving our panel a warm welcome.
Thank you so much to SMU. Colton and his colleagues have done a great job. Give them a round of applause. They really, I do a lot of these. This is very well done, I can tell you, in the packed house is testament. Before I begin, I'd like to show you a video. Some of you may have seen this before, but this is a clip filmed on the campus of Yale Law School. And to provide the context, a student at Yale is challenging the head of her dormitory, it's called a master at Yale, over an email he sent involving offensive Halloween costumes. The context is far less important as actually what you'll see here. So let me play this video first, and then I'll start my shtick.
This section is because other people have rights too, not just one.
Your bandwidth is not nearly as good as mine.
Job, create a place of comfort and home for students that live in children. You have not done that. By sending out that email, that was against your position as master. You understand that?
No, I cannot agree with that.
That's not fucking your second position! What hired you? You should step down! It's not what you think about being a master. You should step down! It is not about reading intellectual things. It is cannot sleep at night. You're disgusting.
Okay. How many of you have seen that video before? Okay, a good number of you. So to summarize, and a couple of pieces were hard to understand. The student was yelling at the headmaster of her dormitory, saying that your job is not to create an intellectual stimulating place, it's to create a home or a safe space, as it's called. This video, I think perhaps more than anything else I will say, illustrates the importance of intellectual diversity on any campus, but I will focus my remarks on the law school campus. And in three primary respects. First, in the classroom, it's critical that all perspectives be heard and that people think that they can speak up and they don't feel like they have to be silenced out of fear of retribution. The faculty lounge, there's something called in-group bias, which is nothing bad, but when people who agree with each other talk amongst themselves, they generally come to the same conclusion. Things differently shakes that up. And even if the position is the same, your argument becomes much stronger when challenged by someone who disagrees with you. And finally, intellectual diversity on the college campus or on the law school campus. This event right here, put on by the Federalist Society, and Colton and his colleagues, is a tribute to that. Bringing in speakers from a wide range of views, talking to you guys over delicious Chipotle, and giving you thoughts of how to approach law school. This, I think, is critical. Now, about a week or two ago, you may have seen that the University of Chicago is becoming freshmen. And I want to read some of it from you, okay? The University of Chicago has a commitment to, quote, freedom of inquiry and expression. Members of our community are encouraged to speak, write, listen, and challenge without fear of censorship, okay? Our commitment to academic freedom means that we do not support trigger warnings, we do not cancel invited speakers, and we do not condone the creation of intellectual safe spaces where individuals can retreat from ideas and perspectives at odds with their own. Now, what's going on here? There's a movement afoot on a number of colleges, maybe you have this in your undergraduate experience, of trigger warnings. Now, what is a trigger warning? At the top of a syllabus or next to a lesson plan, the professor will write, this may be triggering. This may bring up emotions in you that you don't want to experience. So for example, if you're reading something about rape, Greek mythology has a lot of rape in it. So there actually, I think it was at Columbia, where they issued trigger warning, do not read Ovid, because there's involvement of Greek mythology involving rape. Say you're a veteran with PTSD and you're reading Cry the Beloved Country, or something to that effect, right? Couldn't you read that? And the effect of the trigger warning, depending how the professor administers it, is to excuse a student from an assignment. Actually say, you don't have to read this, or you don't have to participate in class. Now, if an individual professor wants to do this, I think there's some academic freedom there, they have the option to do it. The problem becomes that universities impose these requirements. The other item mentioned in this University of Chicago letter is called an intellectual safe space. These have a wide variety of interpretations, and I won't try and define them. But the general idea is it's a place where people are not exposed to ideas that they don't want to be exposed to, or that people of a certain race are only allowed, or people of a certain gender, or even you have LGBT safe spaces where people who don't characterize as such are not allowed to enter. All of these have a very singular impact. The exclusion of ideas on the university campus. People are willingly walling themselves off from ideas because they may find them offensive or harassing or triggering. There's a serious cost here, okay? Now, I'll concede, and I'll give this up, that a lot of the speech that people are saying probably makes you feel bad and probably makes you feel hurt, and maybe you'd rather not be around it. I'm not diminishing those items. And if a person chooses not to associate with these ideas, that's their decision. The problem arises when the university imposes these and they tell professors, especially untenured professors, you can't teach this, or you need to excuse students from this class, or because this is a safe space, you're not allowed to come here, or because the speaker is controversial, we need to cancel the invitation. That is where the problem arises. by excluding speech, you are making it okay to delegitimize it. Say that those ideas are evil. They're bad. We can't have them here. And it's better we simply don't listen to them at all. Rather than have a counter speech. For example, Federal Society holds events. Some speakers are on the right of an issue. Some speakers are on the left of an issue. And at the end, all of you, and I encourage you to ask me questions and challenge me. Push me back. I'm not right about everything. John's not right about everything. Right? We have opinion views, and we can debate them. And I freely admit that. Let's bring this a little bit closer to home, and let's talk about law in general. Law school, in particular, is a place where you're exposed to some pretty heady ideas. I teach constitutional law, right? We talk about abortion, slavery, eugenics, right? All the most hot button issues in a class. And let's say one day I'm teaching an opinion, a Burgerville v. Hodges. You may know this decision, right? This was the same-sex marriage decision decided by the court last year. And let's say I write or say in class, you know, I don't think the majority opinion was well-reasoned. It wasn't. But let's say I don't think the majority opinion was well-reasoned. A student goes to the dean and says, Professor Blackman was harassing me. I am gay, and I think he was delegitimizing my marriage. Okay. Let's say I'm talking about the case of United States versus Texas. This is the immigration executive action case. Let's say I say in class that these executive actions are illegal. They're unconstitutional. I, in fact, do say that. And a student goes to the dean and complains, Professor Blackman, you know, my parents are immigrants, and I think he's harassing because of their race. Okay. These allegations, I think, are frankly baseless. And any responsible dean who has a commitment to academic freedom will say, well, maybe talk to him about it, but, you know, he's in his prerogative to address legal issues. But what coming down the pike is the bar, the state bar. So recently, the American Bar Association proposed a new model rule. You've taken legal ethics, many of you. And the purpose of this model rule is to impose certain restrictions on attorneys. And I'm going to read part of this rule. It's long, but I'm going to read parts of it. So it's professional misconduct for a lawyer to engage in conduct the lawyer reasonably knows or should know is harassment. Okay, how is harassment defined? I'm going to concatenate a bit, but it says harmful verbal conduct that manifests bias. Okay, so if I say something that I should know manifests bias, and I say this in some sort of social activity in connection with the practice of law, such as this room, I'm subject to discipline. I am subject to a disciplinary complaint. This is not hypothetical. I've had students complain of the exact same nature that I described. But instead of going to the dean where the dean says, well, you know, we'll talk to him, the response is, okay, we'll go initiate a disciplinary proceeding. So the same specter of sorts of safe spaces and trigger warnings that we have on college campuses very well may come to the state bar. And if you want to give a CLE one day and criticizing a decision involving same-sex marriage, and someone finds that harassing, you now have to hire a lawyer and defend yourself in a disciplinary proceeding. Make no mistake, you're going to win, right? And I don't think that the state bar will enforce it like this. But these rules exist as chilling mechanisms. They exist to chill speech. They exist to silence people. Why am I going to waste my time going through a disciplinary proceeding if the end result is that I'm going to have to spend money on a lawyer? I'll simply be quiet, and that's where we lose. The second you say, I'm going to stay quiet rather than fight this, free speech is done. This is why these rules, which are ostensibly designed to promote diversity and inclusion, have a serious chilling effect on thoughts that are not in the mainstream. There was a time when the thought on campus out of the mainstream was on the left, the radical left, right? Back in the 60s, and it's all good. Whatever you had to say was good. But we've had something of a reversal in recent years. So my encouragement to all of you, and I'll wrap up in a moment, is to speak your mind. And if one of your colleagues or professor tells you to shut up or don't say something, don't listen. Engage in a reasonable, thoughtful debate. Present your ideas respectfully, always respectfully. Don't heckle, don't call out in class. Be respectful. But the second you say, you know what, I'm afraid of making this point because my professor will be mad at me, or my colleague will disagree with me, or something to that effect. The second you say that, we are on a long and winding path down to censorship, right? It's in your power to promote free speech and promote debate and not to ostracize, or to use the words of academics, other your own views. Thank you very much, and I look forward to your question at the end of this discussion. Thank you.
There's a sign on my wall at home, and it's a reproduction of a museum sign that I saw in New York, and it's a reminder to me of something that my little Irish grandmother told me that her grandparents encountered when they came over from Ireland. It's a sign that reads, "No Irish need apply." And it was unfortunately fairly commonplace when Irish immigrants came to this country. In many ways, we might see a virtual sign on America's law school faculty hiring committees that say, "No conservatives need apply." And that's because, as George Will said, American campuses cultivate diversity in race, skin color, ethnicity, sexual orientation, in everything but thought. Now, I'd like to tell you a story because that's what I do. I'm a trial lawyer. This is a story about Teresa Wagner. She now is married, goes by the name Teresa Manning. She was a University of Iowa law graduate, class of '93, and she wanted to teach at her alma mater. And after practicing in Iowa for a couple of years and then becoming in-house counsel to a couple of organizations in Washington, D.C., she returns to Iowa, and she is working part-time at the law school as associate director of the law school's legal writing center. She applied and was one of 3 finalists for two full-time positions as a legal writing instructor. Now, Professor Wagner is very well qualified. As I mentioned, after practicing, she moved to Washington, D.C. She was in-house, but the organizations she was counsel to were 2 conservative organizations, the National Right to Life Committee and the Family Research Council. Now, in addition to these conservative leanings, she had ample experience teaching legal writing. She had taught it as an adjunct at George Mason University School of Law, as well as a graduate writing seminar at another college. She had edited 3 books. She had written a number of briefs, including a Supreme Court brief. She had edited scholarly work by other law professors who wrote glowing recommendation letters for her. She had even been offered, but declined, a full-time tenure-track position at another law school, Ave Maria School of Law, which is somewhat known for its conservative orientation. Now, during the interview process, one of the members of the Faculty Appointments Committee even suggested to her, "Hey, take that reference to Ave Maria off. It's going to turn people off." Now, at the time, the University of Iowa Law School, and this is kind of an interesting thing to note, had 50 full-time faculty members, 46 of whom were registered Democrats, one of whom was a registered Republican. That not surprise you very much, especially in light of what happened subsequently. So after being told she's one of 3 finalists for these 2 positions, Teresa Wagner ultimately receives the call that nobody looking for a job wants to receive. It's the, "You didn't get the position." And who did get the positions were one person who was a self-described, I'm not using his terms, quote, "off the charts liberal," close quotes, who had no experience practicing law, had taught for 1 semester at law school, had no legal publications, and after he got the job, within a semester, he asked to quit. The dean persuaded him to at least finish out the year, but he was gone within a year. The other person was a law school graduate who was hired straight out of law school. He had been a research assistant for one of the University of Iowa's faculty members who, as a Supreme Court clerk, had actually worked on the brief, actually worked on the opinion for Justice Blackmun in Roe v. Wade. So, Teresa Wagner is told that She's told various stories. We've all heard this sometimes when unpleasant news in employment circles comes our way. She's given various stories about why she's chosen. One was, you didn't have a high enough law school GPA. Well, she graduated with distinction from the University of Iowa Law School, and that was something that only a couple of other faculty members teaching there had. She was also told that her faculty presentation, what's known among law professors as a job talk, wasn't very good. However, we won't really know if it was good or not because the law school destroyed the videotape, as it turns out. Spoliation. But I digress.
Did he use bleach bits?
So we don't have this videotape, but we do have what came out in discovery during a subsequent lawsuit was a number of emails from professors who had seen the presentation, the job talk. One of them wrote, you know, great job, let's hire her. You know, they were generally favorable, but she didn't get the job. So given her suspicions about what may not have done the trick for her, she sued. In 2009 for employment discrimination, alleging that she'd been deprived of due process and equal protection and that her First Amendment rights had been violated on the grounds that she'd been discriminated against because of her conservative ideology. The law school, of course, denied this, even though during discovery there were, you know, a number of rather embarrassing emails, embarrassing for the law school, that surfaced, such as one that read, this is from an associate dean to the dean of the law school. Frankly, one thing that worries me is that some people may be opposed to Teresa serving in any role, in part, at least because they so despise her politics, and especially her activism about it. Well, so what happened? Case goes on, goes to trial in October 2012. After 5 days of testimony, the jury deliberates for 2 days, but they're deadlocked. The jury foreman, after they were released, would ultimately tell the Des Moines Register, everyone in that jury room believed she had been discriminated against. What they couldn't agree on was whether or not to hold the dean exclusively responsible. The dean had been named in her individual capacity. The judge declares a mistrial, but then instructs the jury foreman to sign a verdict form that the dean wasn't liable. This was a procedural error. The Eighth Circuit didn't like it. The Eighth Circuit ordered a new trial, and it goes to trial, retrial, again, last summer, June 2015. This time, after a 6-day trial, the second jury found that the former dean, Carolyn Jones, did not violate Teresa Manning's First Amendment and due process rights. Okay, so we have a milestone case. First time a law school's been sued because they supposedly discriminated against someone on the basis of their ideology. What's happened since? Teresa Manning has gone on to author a book. It's called Academic Injustices. The University of Iowa Law School, during the pendency of all this, maybe they had a come to Jesus moment. I don't know. They hired 4 registered Republicans. How did that happen? I don't know. Admission that maybe they're not doing things on the up and up. Who knows? But, you know, what are the dangers of not having an ideological balance or ideological representation on law school faculties? I consider myself a good trial lawyer. I consider myself good in part because of the legal education that I got. I was fortunate enough to have, of course, I didn't get to have Josh Blackman for con law. I had Charles Allen Wright of Wright and Miller on federal courts, somewhat conservative leaning. But I also had Michael Tiger, who was a 60s student radical who represented Angela Davis and many other, you know, darlings of the left. A good advocate, because a good advocate has to be exposed to multiple perspectives, has to know the strongest argument for the other side. There's no way that you can adequately make your case to decision makers, to judges, to juries, without having this exposure to multiple different viewpoints, multiple perspectives. And that's one of the things that I treasured about law school. Now, there have been scholars. It's a small but growing body of work that I hope to add to in a modest way that have looked at the actual representation of conservative-leaning faculty members on American faculties. One figure a study done by Professor James Lindgren at Northwestern Law School, put it at roughly 80% of faculties are Democrat, left-leaning, liberal, progressive, choose your word, okay? That conservatives, Republican, however you want to word it, are vastly underrepresented. Now, that professor and others have done some updated research, and as recently as last year, some more work has come out that indicates that it's gotten even worse from about the early 90s onward. My own empirical study looked at law schools within Texas, and in some instances at the very far left-leaning side of the scale and by the way, quickly on methodology, some of the studies, and I saw no reason to differ from what other folks have done, is they looked at, because you can look at an article, scholarship of someone, and you can draw a couple of different, opinions. Some people might consider someone, middle of the road. Others might consider that left-leaning. Really, though, what is a fixed yardstick or benchmark has been who do they contribute to politically. So we look at recorded presidential and other political campaign contributions. And so using that yardstick, using that methodology, it's actually even more defined in some instances of the law schools whose faculty members were active giving political campaign contributions. 100% were going Democrat.
Not anymore.
Not anymore. And the figures are never really all that impressive for even schools that you might consider to be conservative. I found one law school in Texas where of the campaign contributions, it was roughly evenly distributed 50-50. So, this is one way of looking at this. It's not a perfect way, but it's a way that certainly, functions. But ultimately, and this is what I say in wrapping up, there are going to be more Teresa Wagners, Teresa Mannings. Law school faculties can benefit from having more conservative ideologies represented among their scholars. Law students will benefit. And if law students benefit, well, then the legal system benefits because you're going to have more well-rounded, more well-qualified practitioners of law. Thank you.
Thank you.
So I guess first I want to thank the Federalist Society for allowing me to come here. This is the second time I've been asked to come and speak a little bit about a subject that, if you read my bio, I have absolutely no expertise in. The first one was tax policy, where I debated Stephen Moore, one of Trump's economic advisors, and that was fun. Professor Cresty was there as well. And now I'm talking about, essentially, as I see the issue, employment discrimination law. I'm focusing not, as Josh did, about lack of diversity, but rather whether it exists in law schools and whether there's discrimination, what explains it. So why I do feel qualified a little bit to talk about it is because I have a genuine interest in employment discrimination law and also a little bit of training in social science. So what I want to focus on is a little bit different, and that is why this problem is interesting from a social science perspective. That is the question of, is there ideological discrimination in schools? Now, I don't think there's any question that there's this ratio that has been described regarding the representation of Republican versus Democrats on law faculties. The question as a social science matter is whether that is because of discrimination or something else. And that's what I want to focus on, and hopefully that'll generate some discussion. I also have some responses, but we'll leave that for the Q&A. So first, I'll point out why this question is, I think, interesting from a political point of view, and that is it causes sort of it causes political actors to sort of play against type, right? Usually, liberals or progressives are up in arms about discrimination, and sort of the right side of the political spectrum is saying, no, trust the free market, it sorts people out correctly. Here, you have usually conservative or actually Republican leaning faculty saying there's discrimination here, and you have liberals offering reasons that they would never offer to explain, say, a gender gap. They would never make these arguments with regard to the lack of racial representation or gender. So it's interesting for that reason. The primary reason why I think it's interesting as a matter of social science is that it's very hard to figure out when you're determining why this happens. You can look to historical methods. When you're doing social science, if you're going to eliminate some reasons, one of the things you have to eliminate turns out to be whether there's quality, whether there's just no good Republican or conservative scholars out there, and it's actually very, very hard to get a handle on what quality means without reintroducing the problem of subjectivity, right? So I'm following along with the structure of one of my former colleagues' recent paper on this subject, where he talks about alternative explanations, some of which have been
Is
given.
Posner's in Chilton?
James Phillips.
Okay.
He's a colleague of mine of all places, Berkeley. Okay, so I was born in Berkeley, so maybe I'm once again the token, whatever. Here. So some explanations are, well, Republican-leaning candidates, lawyers, want to make more money generally, more than liberal people who want to come to be a part of the academy. That might explain it. Maybe it's not convincing. Another reason is that there's a skill difference between the two. And then there's various other reasons, right, that you can go into. Some involving self-selecting and some involving actual levels of skill, but notoriously hard to figure all of these things out. You do use something like how productive a faculty member is, how many articles they write, and how much they're cited. Even if you believe that is an adequate measure of skill, I don't, a lot of social scientists don't as well, then there are plenty of other explanations of why there may be this gap. And so it's an incredibly difficult to pin down in an empirical sense whether there is discrimination in a way that it's not as difficult when you have something like gender discrimination or racial discrimination. So that's the social science part of it. And I'm happy to elaborate on it, and hopefully it was at least somewhat clear. But if you're going to attack this in a rigorous way, it's actually very hard to do. Now that doesn't mean these gaps don't exist. But another question from this perspective of studying this empirically is, what gaps are the important ones? We went back and forth, I think, in the comments between talking about conservative leaning versus liberal, and then Republican versus Democrat. And I think that for various, that changes. It's an important question to ask, what kind of diversity you want. And it also plays into the analysis somewhat, because if you're talking about Republican versus Democrat, over the years, law has become sort of social science and science has become more important to law, right? Law is not an isolated field. We work with findings from other areas, right? And so if there is a particular party at a particular point in time, not conservative versus liberal, but Republican versus Democrat, that finds itself furthering itself from sort of certain scientific consensus positions, then it starts to look like what you have is not so much discrimination, but valid distinctions between different positions. In other words, if you are a climate denier, if you don't believe climate change exists, you're probably not going to get hired unless you've got some incredible scientific proof that will everyone's mind, you're probably not going to be hired in a science department, a climate science department. And I think some people on faculties, I don't know where I come out on this issue, but I think some people on the faculties will be especially resistant in law faculties to the notion that they're discriminating, right? They might say something like, look, if you attach yourself to a party that doesn't believe in our best version of facts, that's not discrimination, that's something else. And if we require ideological diversity, not conservative versus liberal, but Republican versus Democrat, then we're asking for this sort of, we're sort of asking for this artificial notion of equal time, where every time someone mentioned something about the Earth, we have to say, oh, okay, well, we have someone else's view that the Earth is flat as well. And so it becomes this struggle for equal time. Now, again, a lot of the issues, so that's one issue about the difficulties of figuring out whether there is discrimination. In terms of how hiring practices go through, I've never been on the committee, but I recently went through this hiring process at a bunch of law schools, and I can say that in most cases, probably Teresa Wagner is a more exceptional case. I'm not certain of that, of course, but I think in most cases, people don't go out of their way to try to judge directly based on political affiliations. But, and this is a big but, these hiring decisions are highly subjective. And anything that's highly subjective is subject to various kinds of implicit bias, where you don't think you're really discriminating, but you just somehow gravitate towards one. And if the existing faculty is disproportionately liberal or Democrat, however you want to define it, then it has a way of reproducing itself. I'll share a quick anecdote. I was at a conference, American Law and Economics Association, not, by the way, an association that's known to be super progressive. And my friend and then classmate at Berkeley was presenting this paper on this issue of whether law faculty discriminate at a very conference full of prestigious economists. And one of the most famous, who shall remain nameless, said, I think I know why conservative, I can't remember whether he said Republicans or conservatives, but don't get hired. He said, maybe their ideas are just stupid, right? He said it loud and proud, and this is a big deal person. I'm not probably spoiling anything by saying it was a man. This was the Law and Economics Association after all, but that gives some sort of support for the notion that, there are strong political feelings, and this can infect the process. Whether ultimately we can categorize it as discrimination, and whether ultimately we can prove that it was that and not some of the various other somewhat plausible or not plausible, depending on your point of view, factors, is another deal. So I think that's all I have for now, but I look forward to your thoughts.
Cool. What time do we finish here?
1:40.
Oh, we have time. Okay.
We have 40 minutes.
Oh, plenty of time. Great. So I'll take a stab at offering a quick rebuttal. I think both of my colleagues. Very important point that Dave made that is worth stressing. It wasn't just that the idea was stupid. It's that the party that you're affiliated with is a stupid party. And I think that's where the problem arises. Votes for is a very subjective decision. There are often a lot of factors that go into it. Indeed, I don't know who I'm voting. I mean, I'm not voting. Anyway, we'll talk about politics in a normal election, but who you vote for is a very specific decision. The notion that because you affiliate with a party, then that by definition your ideas are stupid, I think does permeate. And the idea that the economist said is, well, maybe their ideas are stupid is bad. Now, the global warming example is a favorite example. Whenever I debate this, that's the first example professors raise. But I'll use an easier one. I believe the Second Amendment protects an individual right to keep and bear arms. I think that's consistent with the original meaning of the Constitution, and Heller was correct. Okay. Is that an idea that is stupid? There are a lot of law professors who say, yes, it's stupid, I'm wrong. Okay. If I were to say, I'm an originalist, which I am, endeavor to interpret the Constitution according to its original understanding, and I disagree with the living Constitution, is that a stupid idea? I think a lot of law professors would say yes. Do I have any stellar evidence to blow you away that originalism is correct? Probably not. It's all been advanced. But far more than something like global warming, which is empirical and you have numbers and this and that and this, law has a lot of policy judgments. And the sorts of policy judgments that I make are based on my study. So the notion that the people applying are simply not as smart or the scholarship isn't as good is insane. If there was a law school that had an 80% white faculty and a 20% minority faculty, something called disparate impact, right? That's in the law, that if the numbers are so damn skewed, there's probably something up. You don't need proof of evidence. You don't need the smoking gun saying, man, I'm not hiring because he's black, or I'm not hiring because he wrote about the Second Amendment. The social science perhaps is good, but in any other area of discrimination, I think, as he said, the numbers would be staggering. Okay? The reason why Teresa's lawsuit failed is that the First Amendment is very hard to prove. And being conservative is not a protected basis in Title VII, so that's not something you could bring. But I'd like to move away from the faculty hiring. John can handle that in spades, and he has the numbers, and I know. I think the important point to stress is, regardless of who is on this side of the podium, 80, 20, whatever, on that side of the podium, it's maybe 60, 40. Okay? Regardless of who your professor is, and I can't control that. You sitting where you are in the bleachers, right? You are more representative of the populace than the professor will ever be. That's why it's incumbent upon you to be very careful to articulate your views. Even if the person up here says, and I know law professor to do it, the Second Amendment, Heller, is absolutely wrong, and if you say that, you're spewing stupidity. Stupid. Law professors say this. I travel the country. I feel like a P.T. Barnum, but I travel the country, and chapters of presidents tell me about the horror stories, so I know it happens. And I know law professors say, if you think Heller was wrong, if you think Roe was wrong, they ostracize them. If you criticize Obergefell, I'll give you an example. Erwin Chemerinsky in his new common law book is not including Justice Scalia's dissent in Obergefell. Why? It's too hurtful. Hurts people. Wrong. So regardless of who's here on this side of the lecture, you're there. And make sure you use your voice powerfully.
I think that the video that Josh showed at the very beginning underscores one of the inherent problems that David alluded to in terms of law school hiring. We have a perversion of the ideals that law faculty members are supposed to hold dear. We have, in the midst of someone exercising a First Amendment right, being shouted down, being told, no, you can't, because I don't agree with what you have to say. Okay? Well, I may not agree with what Colin Kaepernick, does when he, doesn't stand for, the national anthem. But I will defend his right under the First Amendment to express himself, regardless of whether I disagree. Justice Scalia famously disagreed with the fact that someone burns a flag, but vigorously upheld their right to express themselves under the First Amendment and do that. But what we have here is, in the rush to be politically correct, to have the safe spaces and everything else, we have been denying the very protections to points of view that we don't agree. And it's true that people in any hiring situation seek to replicate, their own environment. We hire people who remind us of us. And for decades, that has been attacked because when it's taken to the extreme and it denies rights to individuals in protected classes, whether it's racial discrimination, religious background, gender discrimination, what have you, it is wrong. Just as it is wrong for a law faculty to say, we have several candidates here. Candidate A has more impressive publications, more teaching experience, every reason to be hired, but there's that damn right to life stuff that she's up to. And, this Family Research Council. I know that if I wanted to get hired full-time at a law school faculty, first thing I would do, wouldn't be to hide my publications. Well, they love that, right? Wouldn't be to hide my teaching experience, but I better get rid of that little line that says legal counsel to the Republican Party.
But if you wrote an article at Roe, you can't hide that.
Well, that's right. And that leads to another issue, which has been discussed to a certain extent, which is what effects this has. This can poison academic freedom, which every law school and every law faculty should cherish and guard and maintain. There have been studies showing that conservative-leaning scholars will hide their leanings by, not publishing on more conservative topics or not sharing more conservative views, fear of reprisal in the academy. That has been documented by, more than one study. In terms of a way to illustrate this that I hope will hit home for law students, last year, a 2L at Ohio State Moritz School of Law published an op-ed. And it was an op-ed that responded to Black Lives Matter and was critical. She received all kinds of threats, including threats of physical violence. She went to the law school administrators and shared these threats. She was in fear. What was the reaction? Well, they condemned what she wrote because they didn't like it. They didn't try to provide any protection. They suggested that they did more than suggest, I'm taking a mild term. They said you were wrong in what you wrote, not you had the right to express yourself. You were wrong in what you wrote. And moreover, you shouldn't be coming to us. You should be going to people whom you have offended and seek some sort of reconciliation. That was their reaction. Why? Because they disagreed with what she wrote. Now, as Josh pointed out, this should be a place where there can be a free exchange of ideas, whether you agree with what a law professor says or not, whether he or she agrees with what you believe or not. And this leaning is having this poisoning effect in terms of academic freedom and in terms of freedom for law students.
I had a quick response to, I think, both comments, and that is, I guess, we're all, unless you study classrooms everywhere, and you may very well do that. I'm limited to my own experience as a student, and I spent a lot of years as a student and teaching. I guess I just don't, I appreciate the comments, but I guess I just don't see the world you're describing play out in law school. In other words, separating the questions out about whether there's discrimination in legal law school hiring and what effects it has. It's the Yale and Ohio, or Yale and Ohio State are their own special little places. And the Teresa Wagner story is its own, is a pretty egregious example, but I don't know that I ever experienced anything like what you're describing, where a student says something and the teacher calls them out. Now, maybe partially it's because I'm not so sort of committed one way or the other ideologically, but I don't see that happening. I also don't see, as much as I'd like to have a trigger warning for all Scalia's dissents, for reasons unrelated to ideology, I don't see that happening. And you mentioned a dissent that's left out of a book. Again, though, I think we all get a chance to argue that, and so there's no way to easily that it is. And I appreciate the arguments in general, but I guess I'm seeing something the way I see it. It'd be interesting to hear from students whether they agree, because I don't get the sense that that it exists, and that to the extent that it does exist, whether it comes from professors and how. Do they read a bio and say, oh, try and interpret, whether someone, if someone is a counsel for Trump or something, that's pretty clear. But other than that, you're probably guessing through the teachers, the way they present things, the way they dismiss arguments or not. But I have had, in my experience, a pretty open conversations, I think, but maybe we can see.
Yeah, I'll give another anecdote. One of my colleagues went in the job market, and he written extensively with the Second Amendment. And his entire interview at what's called a meat market, this is at the hotel in Washington, we have these series of short interviews. The entire interview was one professor excoriating him, saying, how can you defend the Second Amendment? This was after Newtown. How can you defend the Second Amendment when all these children get gunned down? I can go on for hours, but this stuff happens. You don't need to be counsel to Trump. If you write the article defending Keller, it's pretty clear. In fact, I actually wrote a second job talk piece because that wasn't about the Second Amendment, because I wanted to present something that was more neutral. I suspected the bias with it, but I agree. Let's hear from the students. I think. Oh, you want to please rebut? Please.
Well, if somebody asks you, how can you defend the Second Amendment after Sandy Hook or Newtown, whatever. I think the response is supposed to be your whole argument. I mean, on the one hand, it's a statement like, I don't like what you're saying, but it's also an invitation to say, like, how can you defend?
Oh, come on.
Defend away.
No. The argument is about originalism. It's nothing to do with what happened in 2014. The paper was on the Second Amendment's original understanding, irrespective of what happened 200 years later. But this is it. You think the article? I mean, but you are making the exact point that the economist made, that this is maybe a stupid idea. That continuing the Second Amendment's original meaning in light of massacres is something worth debating. And those are two separate and totally different points.
And the overwhelming majority of you as law students are not going to become law professors, but you are going to encounter different viewpoints and different perspectives among people you try to convince, among judges you try to convince. I mean, I am a Second Amendment proponent. I have done pro bono work for Second Amendment rights organizations. I have represented probably half the firearms industry in product liability lawsuits. And yes, I have walked into a courtroom in Texas, no less, one of the last places I'd expect to see it, and been greeted by the judge as, Mr. Browning, are you here representing the merchants of death again? Sure.
Yes, Your Honor.
I think there's a little not so implicit bias there, but I still have to do my job as an advocate, and that's knowing the strongest.
Did you win the case?
I did.
There we go. All right, so let's go take some questions from the students. We have lots of time. Colton, if you want to call on people.
I think we're going to hear from the faculty first.
Yes. Oh, please, faculty. Yeah.
Yeah. I spent 16 straight years. So between 1998 and 2013, I read every single resume of anybody trying to get into teaching through the meat market or elsewhere. And what we would do is, we might have 1,000 resumes, and we would narrow it down to 25 people to interview in Washington, and then maybe 6 or 7 people to invite back here. And I have to say that in the overwhelming percentage of cases, 90% of the time, you simply can't tell anything whatsoever about ideology from the resume. And basically, for the most part, from the interview itself. I mean, most of the time, we're interviewing people for technical specialties that aren't necessarily political one way or the other. And consequently, ideology is just never enters into the process at all. Now, I agree that there is a huge disparity, but I think it really is the pipeline. But certainly from my perspective on the admissions committee here, not only were we not making ideological decisions, because we just didn't know anything about the ideology of the overwhelming number of people who were interviewed.
So I appreciate your candor. Thank you for sharing that with us. This mostly applies to public law. Now what's public law? If you're teaching, I don't know, corporations, right, or tax, or maybe secure transactions, politics is not going to show up on your resume. I mean, maybe if you favor a flat tax versus a progressive tax, that might come up. I'm talking about public law, constitutional law, maybe issues affecting criminal law in the sense of various violent crimes. These are the primary areas. Now, the pipeline you mentioned is interesting, right? There is actual studies which John referenced that professors who are conservative self-select. I had people tell me, Josh, don't become a common law professor. You're an idiot. Go teach IP. I had a technical background. I said, go become a patent scholar. No one will ever question you. This was advice. I said, go teach torts. And I don't mean to diminish torts, but I mean, maybe strict liability versus, negligence. I mean, maybe politics not there, but for the most part, not really. I'm talking about public law. And I can count, if I exclude Notre Dame and George Mason, which is where I went to law school, how many federal study members teach common law? In the entire country, maybe 15, maybe 10. This is mostly in the public law, which is, for better or worse, the issues that attract the most public attention, most salient. So how would you know from my faculty resume when I went on the market a couple of years ago? I had several articles on the Second Amendment. I had articles on originalism, right? I had articles on textualism. It would have taken someone 3 seconds to figure out where I was coming from. There would not have been any. I could not whitewash that at all.
And Teresa Wagner, was applying for a legal writing instructor position, and when your legal writing background includes a U.S. Supreme Court brief, normally a good thing, but not a good thing for more left-leaning faculty members on the committee to see that it's on the opposite side of an argument that they wanted to see in a Supreme Court abortion rights case. So, I think, as Josh said, there is, some self-selection there. Professor Ryan.
Did you want to jump in, or I didn't want to jump you off?
I have maybe a quick response, and something that I'm thinking about. I think I would like to hear more later. Maybe it'll come up for questions. How do we distinguish? How are we supposed to distinguish merit ever? If you say, like, if you mention all these things, if you have a publication list that suggests you're a strict constructionist, pro-gun.
Pro-Second Amendment, those are different things. But
pro-Second Amendment.
Thank you.
Person. How are you ever, if you suppose you apply and there just doesn't seem to be a lot of these people getting hired, how do you ever distinguish whether the work is not of the appropriate quality or not? It's inherently a subjective decision.
Oh, of course.
And do we stop the inquiry only once we have the same amount of Republicans, Democrats, and then once we get a third party, we have to include those too? I'm just trying to sort that through, because it does become a difficult issue to figure out if the argument just isn't good enough. Maybe the argument for strict construction is we're not going to have a math equation that shows one or the other, but there may be a better argument in some cases. We have to figure that out in order to determine whether it's pure sort of ideological discrimination or not.
Right. So I think this works well in the sciences, right? If you're a flat earther, so to speak, right? You come in, you're saying Galileo, Copernicus, they're all flat Earth, right? Flat Earth, Earth revolves, sun revolves, whatever, right? That's easy. If you're global warming, whatever, you can do that. With law, a lot of criteria to measure the quality of work, right? We have a tenure process. What are the various criteria used in a tenure process? Well, you have published articles. Where have they been placed, right? Where have you presented papers? Whatever measures you use for the tenure process, I think would be suited just as well. If I publish, as the mark, I published a dozen articles in some pretty decent journals from 1 year of law school, 2 years of law school. That's criteria. But if your idea is, well, if you're a strict constructionist, that's not a worthy theory, then you're engaging the exact kind of ideological litmus test that I think is dangerous. I'm not here advocating that we need to bring back Dred Scott and overturn Brown v. Board of Education. Every litany of possible cases you can imagine. But if I said maybe we should take a second look at Lochner, right? Gasp, Lochner, right? We take a second look at Lochner. If you've taken Conley, what I mean. David Bernstein was my college professor. Now a lot of people say, "Well, that's awful. That's awful. That means he opposes a regulatory state and wants to make child slavery, child labor and everything else." Once you start going down that road, instead of actually reading the article and seeing, well, maybe he's got some arguments. Hey, look, David Bernstein wrote a book called Rehabilitating Lochner. I think makes some pretty damn compelling arguments. But if you simply say, wow, he's talking about Lochner? That's like Korematsu. That's evil. Anyway, Professor.
So I have 2 questions related to methodology. The first one, I guess, primarily for Professor Browning, is when you're looking at the number of law faculty who contribute to the Republican Party or Democrat or something like that, how big is that, and what percentage of law professors are actually contributing?
Sure. And that's a great, that's a great question, because I don't know if it's just a factor of law professor income, which is a subject for a different debate, but the representation, and actually it is, in all fairness, I forget the statistic, but it's some ridiculously low percentage of the American public actually make political campaign contributions in general. I forget the stat, but it's shockingly low. And among law professors, it is certainly considerably higher than the average American citizen. But still, not every member of the faculty is engaging in that. And so, in my empirical analysis, I point out a number of things. First of all, who am I looking at? I'm looking at full-time teaching professors. I am not looking at emeriti faculty. I also ruled out visiting faculty because of the potential that there's just not going to be enough time spent in terms of exposure to students, getting their scholarship out because of the uncertain nature of visiting appointment. Also, I ruled out. I did allow in the sample full-time tenure-track legal writing instructors who are actually, publishing and writing, because obviously, writing is pretty important. I also included members of the administration, such as the law deans, if they also were actively teaching, were included in the sample. And then from that, looked at who was contributing. And usually the percentages, they vary depending on the school, but the percentages were nowhere near 100%. In some, they were actually shockingly high, and by shockingly high, I mean, approaching 50%. In most cases, it's nowhere near that.
So to give another example, Eric Posner at Chicago and Adam Chilton did a similar study. They tried to use political contributions as a measure. There were so few people who donated Republican, the N was so tiny they couldn't even use it. It's like a little n, tiny little n. They couldn't even use it because there weren't enough. But by the way, because when you make a donation, that comes up on the FEC's website, and that could be used against you. Trust me, it's on our minds.
My second methodology question is related to a concern that if we're concerned about how faculty who are not ideologically diverse interact with students and affect the student experience, I wonder how closely that matches political affiliation. So I may be rare, but my politics really do not match up at all with my scholarship and my approach to law. Those two separate things. So I'm just wondering if there's a way to address that. Just
if only more professors were like you. Yeah. There's a good book called Thinking Fast and Slow by Danny Kahneman. And the entire book is about these things called heuristics, right? Where we often are not doing what we think we're doing, or everything we think we're doing is perhaps for the wrong reason. And there's one phenomenon called in-group bias. Now, I'll give you an easy example, okay? If everyone and your friends thinks, oh my God, Richard Nixon's gonna lose the election, right? Richard Nixon's gonna lose. And then Richard Nixon wins, say, wait a minute, I don't know a single person who voted for Richard Nixon, which is indeed what happened when Nixon won the election by a large majority. Not all of us are strong enough as Professor Ryan to suppress our inner urges. No, I compliment you, and I agree. I don't think I am. In fact, one of my former students in the room a couple of times said, well, I'm giving you my opinion here, and I'm telling you what my opinion is, but I try as hard as I can to suppress it. This is only because the academy I live in points it out whenever I am, and I'm very cognizant of this. However, if everyone in the faculty shares certain views, they may be less likely to even be aware of what they're doing, and that's not a criticism. This is our brains are hardwired in a certain fashion that we're not always aware of what we're saying and why we're saying it. Someone else to point out saying, hey, that idea is a little bit off center. That's all you need. Or having a student to point it out. I mean, I've had some fairly liberal students, and they call me. I'm like, you know what? That was a good point. You made a sharp point there. I'm going to tweak what I said. But having that, I think, is important.
I think we have that. I mean, I don't sense that it's something that's missing. But again, the only way to truly know would be a very exhaustive interview process with all.
You are such an empiricist. I love it.
And, well,
I love it. It's good.
It's figuring this stuff out is again just the whole theme of my comments was that it's actually very difficult to do. Right. And a lot of your comments were about if only people would just look at my papers on strict constructionism, my papers on Second Amendment for their merit, rather than just saying this is dumb. And as a someone who wants to think about these issues as an empiricist, I have to figure out, well, how do you know they haven't done that and just decided these arguments just don't hold muster. And because of the nature of the law, unless you're in a specialized discipline like law and economics, where there's a pre-existing sort of process, you can't judge. It's less like science. We're those two opinions converge. You'll never be able to know whether someone read it with an open mind and said, just don't agree with this, and I think this is poorly argued, or it's dumb. It's very hard to do that. I will note, though, that movements like law and economics have sort of, some maybe overlapping with public law, maybe not, but have I think given voice to a lot of conservative arguments, even if they're not quite Republican. Again.
And using Republican, the Republican form of the Constitution, I'm sure.
Yeah, well, the reason I'm making this distinction is because I happen to think that maybe the ideology that's more important is liberal conservative. It seems to me to make more sense, and it's more enduring. Whether a Republican at any given time is doing something, or a Democrat is sort of more fluid and an
I'll tell you what, I wrote a paper on the Coase theorem of the Second Amendment. I will send it to you later.
Sounds great.
Question, just get your neck out of that. You're absolutely convincing that law schools need at least a critical mass of conservative and libertarian type thinkers exposed to that part. No question there. But I think that empirically, to be a law professor, you have to be both fairly intelligent, fairly well educated. And people who are fairly intelligent, fairly well educated, an overwhelming majority of them come around with relatively liberal, progressive positions and think these things through.
Really?
Given that, what percentage of law faculty do you think would there have to be of conservative libertarian persuasion for you to feel comfortable there wasn't a bias discrimination? 10%, 20%? How many do you need to send that message without overdoing it?
I think Chief Justice Roberts asked the lawyer from UT Austin the same question about racial critical mass, and the lawyer definitely dodged it. So I think your point, if I can answer my colleagues looking for papers, is that Republicans aren't as smart. To be Republican, or to vote Republican means you haven't been enlightened enough, right? The fact that so many liberals are voting for Democrats and then they're with more college degrees, more educated, they must know something that we don't. I don't have the numbers in front of me of the number of people with college degrees vote for Barack Obama over John McCain, or whatever it happens to be. But I think it's somewhat insulting to argue that merely because you haven't reached a certain political judgment that you're maybe not as smart as a whole. I think that's an insulting idea that no doubt permeates this debate. That the reason why you reach this is maybe there are not enough smart people on the right. I know a lot of people think that, but I appreciate the candor making the point.
There's a distinction between saying your average conservative Republican is not as smart as your average conservative Democrat, and saying there's no such thing as being a smart Republican.
Yeah, we're talking about a pipeline here, right? So we're saying in the pipeline, the number of conservatives going to the pipeline just can't quite cut it.
Lawyers are above the average in education and intelligence, recognizing that the two are not the same, right? Okay. Well, there have been empirical studies that show that in Texas, at least, the majority of the population of lawyers skews more conservative. That probably is in conflict with what you said.
Now, the argument usually raises, usually I hear it, says, well, conservatives like money more.
Texas is not necessarily accurately representative.
I would definitely agree with you on that. And in fact, there have been studies conducted by the ABA, no less, that shows that lawyers as a whole tend to skew somewhat more left or liberal than the average population. So, there is scholarship, for that. But let's just assume, one of the studies by Professor Lindgren at Northwestern found that the most underrepresented group the most underrepresented groups in law teaching are whites, Christians, Republicans, and male. I guess I'm a four-time loser because I'm a white Christian Republican male. I have no prayer whatsoever of entering the academy. Republicans make up of law professors compared with 38% of the English fluent full-time working population, according to the study. Republican Christians make up 8% of law faculty compared with 33% of the population, of the English fluent full-time working population. Now, if you assume a typical full-time law faculty of 40 tenure track members, 17 Republicans would have to be added to bring it into parity with this population scale. Now, I know the whole argument for diversity in every other context. We want a law faculty that more accurately represents the community that at large. We want a law faculty that more accurately represents the students that they'll be teaching. But right now we don't have a law faculty that represents white Christians, Republican males.
I would argue that saying you want a faculty that represents the community at large is kind of a contestable proposition. You might want to argue that law faculty should represent the best and wisest of the community at large, not represent the ignorant and biased.
I mean, you're proving Dave's point. I mean, I don't mean to be crass, but you're proving the point that if someone worked for Mitt Romney or George Bush's campaign, then they're associating with ignorant people are perhaps not as worthwhile. Oh no, but that's a clear implication of your statement.
Can I jump in real quick?
Please, and then we should get some student questions also.
Oh, of course. Just two things really quickly. I don't think that, correct me if I'm wrong, what Professor Crespi was saying was that Republicans on average are stupider or something like that. I think what you were talking about was a reference to the pipeline, the idea that, I don't know if everyone knows this, but to get hired in today's law market, it's a lot of people, a lot of PhDs and law schools, and there's a heavy focus on the elite institutions, however you define that term. And part of, I think what you're saying is, statistically, as you go up the education scale, you are more likely, in a correlation sense, not in a sort of a necessary causation sense, to be liberal. Because if we hire a bunch of JD PhDs, it just so happens for whatever reason that JD PhDs skew liberal, we're going to be selecting from this. And I think that's one explanation. The other thing I wanted to mention very quickly is that, in some sense, after I read some of this literature, what I wanted to find out was what is the percentage. I wanted to figure out a topic, an area of study that had basically no political element to it. Right? So I looked in mathematics. What's the demographic breakdown of mathematics departments? These are geniuses. These are just weirdo geniuses. They dress strange. We don't know what's going on, but they're really smart at one thing. The study that I read said the ratio of Democrat to Republican was 6 to 1. There's a well-known liberal bias in mathematics, then that might help us understand either this pipeline argument or something else going on. I mean, there's not, it's simply not the case that mathematics departments look at who you donate to. And so there's something else going on. It doesn't have to be Republicans are stupid. I mean, it doesn't necessarily speak directly to the issue in law schools because it's different. Yeah. But it's an interesting, I think it's a hard argument.
Yeah, I mean, the key word Professor Crespi said was ignorant ideas. I mean, that was the word used, ignorant ideas. I think that suggests it's a normative judgment of the people and what they believe.
All right, let's get some student questions.
One question. Could it be possible that if you have 300 applicants for this professor position, and then there are 250 are liberals, and then 50 are conservatives? Why? Because most of the conservatives know they could make more money from practice. And I heard so many times from professors, like, I do this because I love it, not because of pay, So could that be the reason also? Because
I think
if there's too many liberals applying, what are the odds?
No, see, I think that actually I've read a lot about this. Conservatives like to make money more. I think that's perhaps a gross distortion, but I think it's probably true. So if I'm good in math and I can just be a math professor or work at Morgan Stanley or Goldman Sachs and doing international finance, I may choose the latter. I think there's a lot of that where if I can choose to make law professor salaries are a fraction what you make in private practice. But perhaps that describes some of it.
Yeah,
I have about 5 to 7 more minutes.
Oh, okay. Well, let's try to get some more questions then.
Oh, yeah, in the back.
I live now, whatever universities are a brand. So I'm curious why you think it's wrong that as a strong business decision, they pass up the hiring process professors who do not reflect well on that brand or not entice students to find that school.
Reflect well on the brand. I think you're dancing around something. I think I know what you're getting at, but expound.
If you were to hire a professor who's at odds with what the majority of students believe.
Wow. Okay. So I think you have that's an important question. why would you hire someone who's at odds with the majority of students believe? Is that your question?
If it was like, say for example, Liberty University, they are not allowed to go hire the most liberal candidate they have. It's just not in their best interest of the school. It's not good for the partnership on the faculty with the students.
I think the response to that is, and again, students say don't have much of a sense of history. Historically, universities existed to provide a lot of views, including dissenting views. And one of the reasons why you have a dissenting view is because it challenges the majority. So I'll give you a Supreme Court instance. Supreme Court, Justice Ginsburg and Scalia were among the best friends. And Justice Ginsburg would say, the reason why I love Justice Scalia is that even though his dissents drive me nuts, and they probably drive a lot of students nuts, they make me sharper. So the premise of your question I have to disagree with. The reason why you hire someone at odds with the majority is precisely because they're at the odds with the majority, that they can sharpen your ideas. If all you ever hear is what you already know, you're not going to learn anything new. And that's a dangerous place for an academic discourse.
You may consider Texas A&M home to more conservative viewpoints, possibly. And Texas A&M's law school to be home to maybe a disproportionately larger community of conservative-leaning scholars. Not really the case. You know, one of my friends is a member of the faculty there, Sahar Aziz. She is a scholar in areas that I don't really agree with the point of view that she takes, but I think she's a terrific scholar, and I respect her right to be heard and to exercise that academic freedom, and I think she's an asset to the faculty. She may not fit within a Texas A&M brand, but I think she's bringing a valuable viewpoint and sharing that with students. And I think the students are that much more enriched because of it. And I think, you know, they could from hearing from a conservative voice as well. I think there was a question over here.
Yeah, do you think that silencing on campus is harming the right or the left? It seems clear to me it's the right. I feel like the far left too, it's like completely silent nowadays. Don't see any Marxist or communist professors.
Go to Berkeley. Go to Berkeley. Maybe not in Dallas, but go to Berkeley.
You know, the Texas journalism department. Still to that, I mean, it's not that. They're just.
I mean, you have Bernie Sanders rallies with tens of thousands of students. I don't.
Yeah, it seems not. So is there just as harsh of a silencing?
I think if I was in a faculty parking lot with a Bernie Sanders supporter sticker, I'd have no problem. If I put a Donald Trump sticker on my car in a student parking lot, I think I'd have a problem. Other questions?
My question was, is silencing on the left, hurting the left?
Who's silencing Marxists?
So you don't think it's going on?
I'm asking, who is silencing Marxists? I don't know. I haven't seen it. Is there evidence of it?
So you're answering my question.
Yeah, okay. Anything? Yes, ma'am? No, yes, ma'am.
Anyone else?
I heard from the beginning you encouraged us to speak up and freedom of speech. But then, as we discussed, I can also hear that because you speak up, you through publishing paper, you effectively deselect yourself from the job market. It's kind of like, I can't help but keep thinking of Fort Dyer.
Mm-hmm.
The Virginia jury, by speaking, they effectively have to deselect themselves for the most part. But that's because they don't have a choice, because they've been asked questions.
Yeah, it's a real factor. So I'll give you an example involving John Roberts, right, the Chief Justice. Chief Justice Roberts never said anything of controversy his entire career. He went out of his way to never say anything of controversy. He didn't want to sully his nomination to the Supreme Court. So he went up there, he had no paper trail. Don't trim your sails, my friends. Speak up, voice your opinions, and you'll be stronger for it. Your soul will be stronger for having done so. What's that? No, what'd you say? I'm sorry?
I said I feel pretty crushed now.
You crushed? Well, come after. We'll chat, okay? We'll talk it out. I don't want to crush you.
If you speak up like that, and how do you prevent yourself from being selected?
You don't. You don't. But it's better to speak up and be criticized for it than to stay silent, because those around you say, okay, I'm going to stay silent too. By you speaking up, you embolden your colleagues to do the same, and then you serve as a message for others.
One more question.
As people frantically collect eggs. Any other questions? Anything else? Okay, thank you all so much. This was great. Thank you so much.